email not working. So, no idea. Kind of feel like you want to keep everyone that. How many? Got most of them. There were the ones that they picked off at the front of the morning because there was two left.
All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Peter Bergeron presiding. Stand set. Please be seated.
Morning, Council. Welcome to the First District Court of Appeals. We have one case to be argued orally on the docket this morning, which is Eagle Realty Investments versus Dumont. If Council could please introduce yourself and indicate your readiness to proceed.
Brad McPeak, Your Honor.
Okay.
I'm here for
Andrew Schieffer, Your Honor, for Graham Hirschman, Michael Payne, and Helen.
Okay.
Morning, Your Honor. David Hine and Emily St. Cyr on behalf of the plaintiff appellees, Eagle Realty Investments, Inc., Frontage Lodging Investment Holdings, LLC, and Vail Hotel Holdings, ESHB, LLC.
Okay, great. Thank you. And Mr. Schieffer and Mr. McPeak, how are you dividing your time today?
we're going to reserve 4 for rebuttal.
Okay.
And then in the opening session, I think I'm going to do 6 or 7.
Okay.
It's not going to be completely. But I'll bring my
Okay.
phone. It would take my daughter and bring my phone.
Well, we'll have I'll put your yellow light on at 6 minutes.
Oh, that's great.
And then you can figure out where to go from there.
I feel like in the old days, they always said, keep your own time and good luck.
Right. Well, we try to help you out a little bit. So please come forward.
Thank you. Good morning, and may it please the court. My name is Brad McPeak, and I'm here obviously for Peter and Julie Dumont. And what I want to do is focus on the first assignment of error, which was the trial court's decision by which it granted summary judgment in Eagle's favor on a personal guarantee. And the amount of the judgment was $9.9 million after a $4 million or so set-off. And to get to that extraordinary number, which to me heading into that particular argument wasn't even on the menu, the court had to make a number of errors. And I'm very aware of the limited time I have, so I'll try to summarize them, but I certainly know that the court will jump in when it has any questions. First off, the big issue, I think, is that the trial court ignored Hazelton. That was the general contractor. And what made this particular deal, I think, so peculiar in all the operating agreements and all of the guarantees I've ever reviewed, as the court saw, Hazelton was a prominent character in all of those documents. I've never seen an operating agreement before basically say, thou must hire this particular general contractor. And I think that's especially significant in this case since they didn't have a deal with Hazelton at the time.
Well, Mr. McPeak, if you could clarify something for me. So it was around February and March of 2015 that Hazelton provided lower pricing. I think it was $42 million, but then Eagle determined that it wasn't going to go forward with that, correct? So Hazelton was pretty much out of the picture at that point. But then it's my understanding, and correct me if I'm wrong here, that in June of 2016, all of the guarantors reaffirmed their obligations. Is that correct?
They signed a reaffirmation of guarantee, that's correct.
Okay, so my question for you, could you address what effect that has?
Sure. First of all, I think the other side recognizes it really had no effect because they didn't sue on the reaffirmation of guarantee. They only sued on the guarantee, number one. But when one reads the reaffirmation of guarantee, all it says, Your Honor, is we are reaffirming the old obligations. And the old obligation, they didn't expand the obligations, for instance. They didn't expand. The key section is section 2.1 of the original guarantee. That lists the guarantee obligations. When they signed the reaffirmation, if one just looks at the plain language of that document, It doesn't say anything other than we.
Right, but I mean,
What we did
getting back to Judge Bach's point,
Sure.
if you're right that that Hazelton is the crux of the guarantee, if that's not effective, like, why would you have signed the guarantee? Like, what effect is that? I mean, that seems to cut against your argument. I'm trying to understand, like, how you reconcile that from a contractual interpretation.
So the court, obviously the court knows the principles of contractual interpretation.
Right.
If the reaffirmation is unambiguous, and if it only says you're still bound by 2.1, you know, what was going on factually at the time maybe is more context, but less has to do with the interpretation. But I think what we saw in a lot of this wasn't really argued. But what we saw were efforts by Peter Dumont especially to keep trying. He's a real estate developer. Those guys are always just trying to get the deal done. So maybe Hazelton was going to come back into the picture, maybe not. They were working with other people. What should have happened probably, looking back, is everyone should have called their lawyers the moment Hazelton was out and modified. I mean, Eagle would have absolutely benefited from modifying the operating agreement and modifying the guarantee to include other people who were not Hazelton. But Hazelton is sort of who everybody is stuck with, for lack of a better term, because that was the person that was sort of embedded into these documents. So I understand that when I first saw the reaffirmation of guarantee, I'm like, yeah, that doesn't look like a good document for us. But when one reads it, it doesn't expand anything at all. Moving on from Hazelton, I think also the court sort of misconstrued what kind of guarantee this was. This was a limited construction guarantee, and in misconstruing the guarantee, what that led to then was sort of any sort of dollar that Eagle spent all of a sudden was on the menu of damages that the court was going to award. And that, and the equity contribution comes to mind. $10.5 million was awarded. That was Eagle's investment. But when one looks at 2.1, again, that's the 8 guarantee obligations. This was not a guarantee of investment at all. Yet the trial court awarded that. Ohio law is clear that basically.
Well, yeah, and so I understand that, and I think that, you know, certainly with a construction project, you know, one of my just kind of questions in my mind is like, how did you spend $10 million if you didn't like actually build anything, right? And I know there's like damage computation and everything, but are there specific line items in the damages that you all have contested and say that's not appropriate? In other words, like, you know, they're inflating the damages, and here's why. So what would be your strongest argument in that respect?
Sure. Well, we actually contested all of them, and I should probably get my reading glasses, but you have the $10.5 million in equity. And what I always use the verb filter. If you filter that number through 2.1A and go all the way down the 8 different ones, equity is never there, so that's gone. They did $69,000.
But the equity is for things related to the project.
It was in anticipation of a project that never really, to use a sports analogy, never got out of the batter's box. Mm-hmm. What they may have a claim under the operating agreement. Mm-hmm. They didn't sue under the operating agreement. Let's say, and I'm not saying they do, but they should have maybe looked at the operating agreement. That has warranties, that has representations. One of the things it says is if the project's not moving forward, and I'm obviously paraphrasing, they can increase the number of people on the executive committee from 2 to 3. And by that, Eagle then would get 2 votes, Mr. Dumont only gets 1. At that point, they can take control of the project. So there are remedies in the operating agreement, but we're only here in this little guarantee. And that was never really adjusted, I think, to account for some of the damages they want. So the court asked me, and we listed every one of these damages in the brief. Right. But if you filter any one of those numbers, like they put in attorney's fees for a Colorado litigation, that's not listed anywhere in those 8. And the court really wasn't asking too many questions about any of this. And that gets me sort of to my third point.
Well, so on that one specifically, that was a significant number, as I recall. Like, did you all challenge like the those fees are unreasonable, or the billing rates are too high, like,
Well, there's two different fees, Your Honor.
yeah.
I'm talking.
No, I understand that.
Yes.
I understand, but specifically related to the Colorado litigation, like,
No, we just said, we started with, to me.
you just said they're not recoverable under the
I
contract.
went A through G on the guarantee, limited guarantee, and just said, no.
Right, okay.
And also getting to the point about the court not asking, and I see I'm out of time.
You got a minute, you're
Okay,
good.
thank you. The court really just, honestly decided this case on the concept of skin in the game. And these guys are good lawyers. I like to think we know what we're doing on this side as well. No one in this room said anything about skin in the game or the fact that they contributed a whole bunch of money. The court, I think, may be unfamiliar with maybe how contributions to limited liability companies work, was focused on who put money in as opposed to whose contributions were just going to be services. And she really elevated that above everything else and decided that justice needed to be done, and justice to her was just giving them all of their money back, which was not what any of these documents say you should do. Thank you very much.
Thank you. Mr. Schieffer, I'll give you 4 minutes.
Thank you, Your Honor. Good morning, and may it please the court. Andrew Schieffer on behalf of appellants Graham Hirschman, Michael Payne, and Helmut Horn. First of all, I want to echo my support for what Brad McPeak said. I think he did a very good job in covering sort of the limitation of liability within the limited guarantee of a construction contract, as well as talking about the condition precedent regarding Hazelden. What I'd like to start off with is...
Well, before you start, I'm going to focus you in on one part of the guarantee, and that's section 2.2. How does that affect your client's obligations?
Yes, Your Honor. Section 2.2 talks about how the guarantee is a continuing guarantee, and what we included in our brief, and what I believe what Section 2.2 does is make it sort of a revolving door of credit, if you will, in the sense that if Eagle and plaintiffs were to, excuse me, Your Honor, if certain debts that were owed under Section 2.1 were to be paid off, that would not alleviate the conditions upon the remaining debts. And if those debts then were then to be re-forwarded or repaid by Eagle, that they would be subject to those same conditions. And so we don't believe that Section 2.2 adds any obligations or changes anything, expands the bucket, if you will, under Section 2.1. It simply says that if there is a revolving credit relationship with those debts, that they would still be subject to the same conditions. What I'd like to talk about is our assignment of error number 3, where we believe that the trial court should have started, and that's with the procedural issue of allowing what we refer to ourselves as the non-Dumont defendants to amend our answer, and that it was an abuse of discretion. The trial court really, in the record, shows that we asked the trial court to address those procedural motions first. We believe it was appropriate to set the table, if you will, before jumping into the substance of the motions for summary judgment, so that we could understand clearly what defenses were available, which affidavits were available.
But and correct me on the timing, but wasn't this really close to the summary judgment deadline when you moved for leave to amend?
You're correct, Your Honor. The motion to amend did come right around the same time as the motion for summary judgment. But the case law that we cited and what we believed is, one, Ohio law says that delay alone is not a sufficient reason to not grant a motion to amend. Two, the real question is to look at prejudice. And the plaintiffs, Eagle, while they claim prejudice, were not able to point to any specific reason why it would be inappropriate for the non-Dumont defendants to amend their answer. They say things such as, this presents a whole new issue that we're going to have to address. However, the Dumont defendants, in their answer, did raise the issue of condition precedent. So that new defense had been known from the time of the pleadings the original pleadings were filed. Additionally, as we argue, this is a fairly straightforward legal argument, whether or not there's a condition precedent in the guarantee. That doesn't require additional depositions. We didn't ask for an extension of the case scheduling order. We didn't ask for discovery to be reopened. We felt that it was.
Well, I know you didn't ask for that, but wouldn't that be presumably what the other side would want? The other side would say, like, well, I want to question your witnesses on these things. I've already taken their depositions.
Correct, Your Honor, but we believe that, given what was known, that was not necessary, right? We are asking for a purely legal interpretation of the contract that didn't require additional facts, and the facts that were needed to resolve that issue were not in dispute. So I see that my time is up.
No, you've got a minute. The yellow light means you have a minute, so you're
Thank you, Your Honor.
good.
So for those reasons, and for the reasons that, the trial court, I think the record is clear, forgot to address the procedural motions. She ruled on the substantive motions, left the courtroom, was reminded that there was a laundry list of procedural motions that needed to be reviewed and ruled upon, came back in and sort of haphazardly and with one broad stroke dismissed all of them as
Well,
moot.
wouldn't they have been moot based on her decision? I mean, if she was correct, saying that the contract provided, the guarantee provided for the equity contributions, wouldn't that motion have been moot?
I think that that's technically true, Your Honor, but it also sort of puts us in this position that we are now, which is one that we had raised at the time, that we didn't want to be at the appellate court arguing this procedural motion again. Would have liked to have had that resolved so that we could focus on substantive motions. And that's why I believe it was an abuse of discretion. Thank you, Your Honors.
Thank you. Ms. Ryan?
Good morning. May it please the court. There are a great many things wrong with the appellant's arguments. Chief among them, the fact that the assertion that there is a condition precedent is fiction. The parties all agree that the court has to interpret the guarantee.
Well, so I hear your argument, but I got to tell you, I've dealt with a lot of guarantees. I've dealt with a lot of LLC agreements. I've never seen a provision like this that is specific to one contractor, professional, whatever, and doesn't say some other clause if he's unavailable or if we can't reach agreement with him, like we go to Plan B. So how are we supposed to interpret that? I understand you saying like it's not really condition precedent, but how are we supposed to interpret that?
So there are a few things to bear in mind that the appellants never addressed. The first is that in recital B, what they cite as the condition precedent, it states that Holdings, which is at this point a plaintiff appellee, was at that time in the sole control of the defendants. And Mr. McPeak cites the operating agreement repeatedly. Section 2.1 of the operating agreement makes very clear that the defendants, as represented through their LLC, PH Vale Hotel Holdings LLC, which was a member of Holdings, was the managing member, which was in turn controlled by Mr. Duman. They had the sole responsibility to enter into the Hazelton contract. Your Honor made in a question, suggested that it was Eagle in February who determined that we wouldn't proceed with Hazelton. That's, if I may correct the court, actually not what happened. Mr. Duman presented a proposed GMP from Hazelton that came back about $10 million over the budget that they had presented. And our response was, we're not going to cover, and let me be clear, the plaintiff's appellee's response was, we're not going to cover the balance. That's not what the agreement was. The agreement was that you will cover anything over the budget. So if you want to proceed with Hazelton, that's fine. If you want to go and find somebody else, that's fine. And that's what Judge Marsh put her finger on when she said it doesn't matter if it's Hazelton. That's very clear in the emails and the documents that were contemporaneous with all of this, is that under the operating agreement.
But you're saying it doesn't matter if it was Hazelton. I mean, this is not just someone to paint the interior of your house. I mean, this is, presumably there was a reason that you all picked this person or this company. And like if they had said, well, we want to go with Joe Smith and his contracting company, you guys might have balked at that and said, contractually, you can't do that.
Your Honor, actually, No. So under Section 2.1A of the operating agreement, Mr. Duman had unilateral authority to make that determination. And under Section 2.4, which designates certain transactions that are allowed to be reviewed by the executive committee, which at the time was comprised of Mr. Duman and Charlie Thomas on behalf of the plaintiffs, as long as the executive committee provided authority to go with any other contractor, then they had permission to do it. It is undisputed in the record that Charlie Thomas, on behalf of the plaintiffs, provided them with authority to proceed with whatever contractor they chose. They chose not to proceed with any contractor because they couldn't find a contractor who would satisfy the GMP. It's also important to understand, Your Honor, and this too is undisputed, that the reason the guarantee was executed in the first place is because the plaintiffs asked for a GMP that would satisfy and be consistent with the budget presented by the defendants before we entered into any of these transactions, before we presented any of the equity contributions. Mr. Duman, as the developer, said, no, let's not get a GMP right now because if we wait until the fall when the contractor's busy season goes by, we'll have better leverage. And in response, the plaintiff said, if that's what you want to do as the developer, that's fine, but you're going to need to guarantee that this project gets built at this budget. So you're going to need to sign this guarantee. And he said, yes, that's fine, we'll do that. All of that, Your Honor, is memorialized in Exhibit C to Mr. Duman's affidavit, which was submitted with their memorandum in opposition to our motion for summary judgment. The court walked through all of that in the hearing. It's factually incorrect to take the position that they are taking, that this was a condition precedent. And if there is one case that the court should take away from this hearing, it is the First District's decision from 2005 in O'Brien versus Ravenswood Apartments, where this court acknowledged that guarantees stating that the guarantee obligations are unconditional and absolute must be interpreted as such, that they are indeed unconditional, which means that they have no conditions. And similarly, if those unconditional and absolute guarantees include broad waivers of defenses, the guarantors are thus precluded from asserting those defenses. This case, Mr. McPeak referenced Section 2.1 as the key provision. Respectfully, it is not. It is Section 2.3, which none of the appellants have ever mentioned. And Section 2.3 states that this guarantee shall remain in full force and effect without regard to any circumstances or condition. And it goes on to state that the guarantors hereby expressly waive and surrender any defense to their liability under this guarantee based upon any of the foregoing facts, omissions, agreements, waivers, or matters, whether or not the guarantors had notice. And because the court...
Right, but that can't mean that there doesn't have to be a basis under the contract to hold them accountable. Like, you can't just walk into court and say, well, you waived everything, so just give me judgment.
Well, and we did not do that, Your Honor. We
Right.
came in and we established...
Well, but I think that's kind of where your argument seems to go at certain points in your brief, that means that they cannot defend some of the arguments that you're raising.
Well, the arguments that they've waived, Your Honor, the defenses that they've waived, I don't believe they have grounds to assert. And if I may, Your Honor, the parties agree that the purpose of interpreting this is to divine the intent of the parties. And Section 2.3 states unambiguously that it is the purpose and intent of this guarantee that the obligations of the guarantors hereunder shall be absolute and unconditional under any and all circumstances. So there can be no question as to what the purpose and intent of the parties were. With regard to Mr. McPeak's notion that Hazelden could come back into this agreement at some point, by 2016, when the reaffirmation was executed, Hazelden had sued the defendants, didn't tell the plaintiffs about it, but they had sued the defendants because the defendants took the $10.5 million in equity contributions, hired those people to tear down the existing structures, and then stiffed them. So Hazelden wasn't going to come back in this picture. But that doesn't matter, again, because under the operating agreement and pursuant to the undisputed evidence in this case, they had permission to proceed with literally any contractor. With regard to the reaffirmation that Your Honor addressed, it respectfully does matter, notwithstanding Mr. McPeak's assertion to the contrary, and it does say something other than the guarantee is still in place. It says specifically that the guarantee is still enforceable and binding, which is contrary to the arguments that they are making now. And it also says in July of 2016 that they have no defenses to their liability for the amounts that every single one of the defendants testified they owed. The defense that they identified when we took their depositions was not a condition precedent. It was, we don't have the money to pay you. That's it. The one exception was Mr. Duman, who said, well, maybe force majeure, which is a defense that they have never raised in this case. So we went through this process. We tried to understand what obligations they had or what objections they had to their obligations. They didn't assert any.
When was the issue of equity raised, about equity not being covered in the guarantee?
The first time that the issue of equity was challenged was in a motion for reconsideration.
So it wasn't raised at any point during the summary judgment motions or anything else?
That's correct, Your Honor. The caveat that I will put in there is that it was thrown out as an example in 2 sentences in the memorandum in opposition to our motion for summary judgment by the Dumans, but it was not further elaborated on, and they did not mention it during any of the argument in the motion for summary judgment. With regard to Judge Bergeron's question about what other line items they challenged, Mr. Duman said all of them. Pardon me, Mr. McPeak said all of them. That is categorically untrue. They have never challenged any category of damages with the exception of the equity contributions. The equity contributions are set forth very plainly in Section 2.2. It does say that the contributions are guaranteed just as the initial guarantees, those being the ones referenced in Section 2.1. Further, even if it didn't, under Ohio law, these are the compensatory damages because this is the consideration that we paid in return for the guarantee, which they did not satisfy. Section 8.8 of the guarantee makes very clear that the material inducement that they made was signing this guarantee in order to prompt the plaintiffs to pay all of these equity contributions. If the court takes this as if I contact you and say, I want to buy your box of widgets, I'll send you $100. All you have to do is send me the box of widgets. If I pay you the $100 and you never send me the box of widgets, the compensatory damages are, in part, the $100 that I already sent you. That's what we have here. They signed this guarantee and promised to do a bunch of things. We gave them $10.5 million in equity contributions. In return, they didn't do any of those things, so we were out the $10.5 million.
Was the 10.5 went to them rather than were you paying the bills directly or were they paying them?
It was paid to, technically through an account that was held by Vail Hotel Holdings ESHV at the time, which again was managed and operated exclusively by the defendants. So it was in their custody. They used that money. And that money went to purchase a property, which they then, unbeknownst to the plaintiffs, and this gets to some of the other categories of damages, such as the Colorado litigation, unbeknownst to the plaintiffs, actually took steps to encumber that property with a completely unrelated development, which had catastrophic consequences on the value of the property, which is why when we tried to mitigate damages, we were only able to recover approximately $4.6 million rather than the $10.5 million or so that the property was initially worth. It was because of their conduct where they, frankly, lied to the town of Vail and lied to myriad other contractors, got them to work up a project, encumber the property, and then didn't pay any of them. So again, on a second project on the same piece of property, they had millions of dollars run up and didn't even break ground. I mean, it's really difficult to, and this touches on the skin in the game issue that Mr. McPeak mentioned. It's really difficult to live with these facts for any amount of time and not come to the conclusion, and I don't take this lightly, but that the appellants were con men. And what happened here, and the reason why the court was asking about the skin in the game, was for 2 reasons. One, she was trying to make sure that she understood the nature of the relationship. Primarily that the plaintiffs were the only ones who were putting money in, and that, as she noted, this guarantee was all about inducing that. That's set forth explicitly in Section 8.8 of the guarantee. But second, she was trying to reconcile the distinction between what I believe we could say moral culpability and legal liability, because it is certainly true that amongst the appellants, there are some that are more perhaps morally culpable than others. But as the defendants themselves acknowledged in the trial court, That distinction does not matter. It is binary. And if one of them is liable, they are all liable. So the court went through that exercise and ultimately concluded that whatever misgivings she may have had about holding the non-Dumans liable when she felt the Dumans were the ones who were primarily responsible, she couldn't make that determination. So the soundbite, this skin in the game point that they have hung their hat on, is really of no moment. With regard to the non-Dumans argument that the court denied them leave, I gotta say, she allowed them to make the argument, regardless of whether they had formally asserted it in their defense. They stood there in court during the oral argument on December 1st and argued about a condition precedent.
And was there any other basis in their motion for leave to amend besides adding that defense?
None whatsoever, Your Honor. And I do want to clarify one thing. When you said, wasn't it around the time of the motion for summary judgment? It was actually 3 months after the motion for summary judgment was filed and after we had responded. And this court's decision in Kassem, which I believe is a 2020 decision, said that when you file a motion for leave that late in the case, it is prejudicial. The Supreme Court of Ohio reversed a trial court, finding an abuse of discretion because they granted leave to amend that was filed to amend the pleadings to assert defenses after a motion for summary judgment. And the 8th District in Harris said that was, I believe it had the specter of prejudice. The delay was so significant. So when we're talking about the delay that's at issue here, and the non-Dumans are saying, well, delay alone is not enough, that's not the context that we're talking about. Those cases are talking about like 6 months after the complaint was filed or a year after the complaint was filed when the parties are still in the throes of discovery. Those cases are not talking about a situation where we've gone through years and years of discovery, extensive depositions, already briefed summary judgment, and then for the first time raise a defense that has never been waived. With regard to the non-Dumans' invocation of the Dumans' answer, first, I don't believe that a party has a right to rely on another party's pleading, but second, the Dumans didn't assert this defense. They paid lip service to it among 21 other boilerplate defenses. But Civil Rule 9C specifically says that you must articulate with particularity a condition precedent in order for it to be preserved. And if you don't, it is waived as a matter of law. There was absolutely no reference in their answer to Recital B, to Hazelden.
Oh, I don't think they've got that obligation at the pleading stage.
Your Honor, I think it's...
They have to develop the argument at some point during the litigation, but I don't think that failing to give that particularity in the answer is going to waive that defense.
Your Honor, the First District's decision in Bronskill takes a slightly different position and says that they do, and Civil Rule 9C on its face says that it does. But if that is the court's position, I respect that, and the reality is that they did not then develop it.
Right.
And we questioned the appellants at their depositions about their defenses. The appellants, the Dumans, in their brief say that we never asked Mr. Duman about his condition precedent defense. That's objectively false. We did question them about all of the defenses, and we specifically asked them generally, what defenses would you even have? And they did not identify this at any point. The first time that anybody in this case invoked Recital B as an invocation of a purported condition precedent was in the non-Dumans' motion for summary judgment.
Thank you, Mr. Heiner.
Thank you.
Mr. McPeak.
Thank you. Just a clerical thing first. I think there was a suggestion that I may not have raised the problems and the causation issues with their damages. I had a whole section that wasn't just a sentence. Plaintiffs failed to link their alleged damages with Section 2.1. They had the burden as the party moving for summary judgment, and I basically pointed out that there was no link, and I gave examples. I didn't give Judge Marsh every example, but I certainly mentioned the 10.5.
But your argument there was they're not entitled to these damages per the contract, not that there's a dispute of fact as to certain line items under those damages.
Mine was they're not entitled to judgment, and probably, in fact, a step further, I'm entitled to judgment, I would think, but my argument, Your Honor, was they're not entitled to judgment at all for the damages they're seeking, which were listed in the Thomas affidavit, because all he said was, these are our damages, but he never actually fit those within 2.1 because it's impossible.
Right.
Which then brings me to my next point. If I'm just someone up here defending a document that's supposedly unambiguous, I would sit in front of the court and I'd be reading from that document and not talking about how we got conned and talking about emails and talking about facts. I would be taking the guarantee and I'd be going through 2.1A and I'd be saying, they guaranteed completion. This number is completion. We haven't heard that in 18 months of briefing. They've never done it, and he didn't do it now. I would have said B is also completion. They know they can't do that because one of the definitions of completion involves Hazelton. You have to have Hazelton to have completion. You also have to show that there were costs incurred in compliance with the development budget. All the guarantees anyone in this room has ever walked into court on, you go to the judge and you say, there's a lease, they breached the lease, this was the rent, it's right here, we're entitled to this rent. This is so unlike any other guarantee case in that they just look for dollars, but they never tie it to anything. So to me, the fact that you have someone defending an unambiguous document, but then going into a bunch of facts and never actually talking about the documents should be, I hope, a sign that maybe our side should be carrying the day on what these documents actually say. And if the court just focuses on what the documents actually say, I do think Judge Marsh she had a villain in mind. They say, this guy was a con man. If that's the case, go sue for fraud, sue for rescission. That's a different remedy. That's a different case. Go sue Mr. Dumont under the operating agreement for fraud. That's how you get your money back. We all know that from contracts law. Rescission, you get your money back. Go do that, but not this guarantee. And that's all we're here on, is this one. That's the only document they sued on. I finally just want to conclude. I learned something during the course of this case. 9C is actually a pleading rule. I think everyone thinks it's some sort of rule where you have to list all the specifics of your condition precedent defense in your answer. That's not true. If they say we complied with everything at that point, the burden shifts in the answer to say, no, they didn't, and here's why. It's not an affirmative defense that we waived. I'll also say, speaking for Peter Dumont, he never said that I owe any money under this. They keep saying all the defendants have admitted breaches. They say that in their briefs. That's not true. He said he didn't. Did he use really great legal terminology for why he didn't? No. He said the cost of constructions went way up, which was one reason why Hazelton could no longer be involved in the project. I think that's all I have, Your Honor, unless the court has any questions.
All right, thank you.
Thank you.
Thank you both for your arguments this morning, or thank you all for your arguments this morning. Case will be submitted. We'll get a timely written opinion, and hope you all have a great day.
Thank you.